Prashant, your UK immigration lawyer. Just to state what I will cover in this live. In this live, I will be providing latest UK visa advice updates, also provide any brief answers to your questions about UK visa applications, including EU settlement scheme and British citizenship. I will prioritize in this order. Uh, Live questions first, with priority in the live questions for members questions, and then the questions through comments on the channel. On the channel also I'll try and prioritize the members questions. If you stay throughout the live, I will keep on giving important updates from home office, application process, etc, etc. So and other viewers have benefited a lot, saved considerable sums of money in advice for short questions and answers. So stay throughout the live or watch previous lives and you will see for yourself. Stay until the end of the live, and towards the end I will be sharing some important updates on several items. So yeah, and to begin with, let me give a new update. So I think everyone, I'm not sure whether everyone is aware of it. EU settlement scheme automatic update of from pre-settled status to settled status will begin shortly. Home Office has confirmed that. I'll provide details in some video. Maybe I will have to make a video over a period of time, but that's one of the updates. There are several updates I'll go give throughout the live. Currently I will be walking. I'm going to one of my friend's place. So she is an piano expert or whatever you call it, and she is going to set up a record for Guinness World Record for playing continuously for 11 hours. Yeah, so a little disconnection, but then I think internet is fine here. So I will take the questions live. Yes, hello. Orombi, yes. I will go there. I will give you a glimpse of that, the Guinness World Record that she's setting. So I think the best I understand is she's going to play the piano, different types of songs, different genre, etc. And she's going to play continuously for 11 hours or more, I think so. And I will also be witnessing and signing that document for Guinness World Record. So yes, I'll walk there, I'll take the questions and also give updates as I go. So some of the common questions that I've got on the channel, I will try to cover them till the time I don't get any live questions. So let me see my directions first, which way I have to go. Okay, I have to walk maybe this way. Yeah. Okay. Yeah, I don't know where I'm going, but I have navigation open and I will answer the questions. Anyone coming live can ask your questions. I'll try and answer to the best of my ability. Okay, but I'm just trying to open my phone properly. Oh my. Okay, so here I am. Yeah, I'm going in the right direction. Okay, so Orombi, your question, a live question, let me cover that one first. I was refused a UK visitor. Sorry, let me recenter my navigation so I don't get lost. I should keep walking on this way. I need help. I was refused a UK visitor visa to come for my army assessment from Uganda last year when I was working part-time after school, but right now I am at university. Can I explain that? Yes, whatever your situation is, I refused a UK visitor visa. So what is the reason for refusal? I did not get that. I know that you are doing something, you are part-time at university and all, and you wanted to come for some reasons. I don't know what are the refusal reasons. If you tell me the reasons and what explanation you have for that, then I may be able to. Why is this navigation not working? Start. Okay. So give me the reasons of refusal and what is the explanation you have. Yes, you can give that, but it is the caseworker's discretion to assess the reasons, and only then they will consider it. You can reapply again if you think that the reasons may be justifiable to them. Okay. So next question. If someone overstays in UK, go back to home country, it is better option. Yeah, if you overstay in the UK, it is better option. Yes, you should go back to your home country, I think. Unless you have any basis of stay in the UK, most probably you should be going back to your home country. Thank you. Okay, so yes, I would recommend if you don't have any basis of stay, yeah, maybe. And if you have any basis of stay, you can apply from your home country as well. Benga, I thanks. Thanks for giving your vital information. A friend of mine, thank you, applied for himself and family for a graduate visa since 30th of December, and since date he is yet to be emailed of his approval. It takes about 8 weeks. That's the standard decision processing time. 8 weeks would be at least 28th of February. So yeah, he needs to wait unless he has filed priority. I think you do have priority. Yeah, standard service would be 8 weeks from the date the documents were uploaded. The document upload step is completed. Okay, next. Benga. Okay, so I answered that one. Since were ties and I didn't attach personal statement. The sponsor. Yeah, the sponsor, they will not give much weight to the sponsor for a visitor visa. It's your conditions. So the ties are the main one. Your personal ties for every visitor visa refusal. The important thing you need to remember is that is maybe I have to go this way. Yeah, your personal ties, especially financial ties. You should preferably you have some finances, job, savings, investments, whatever that is. Without that, it is very hard for to justify home office. Financial ties is where it ends up, but you should also try and submit documentation for personal ties, family members, religious ties. If you're going to a church, mosque, temple, whatever, get any religious where you are involved in, and any types of ties, social ties, financial ties, family ties, any ties that are the reasons that you will go back to your home country. Mainly, they are always concerned with financial ties. The sponsors' circumstances are completely irrelevant. Less than 5% weightage is given in case of a sponsor that you have in the UK. So, yeah, if you cannot show much ties, then preferably don't waste your money filing this visitor visa. They may not give you. So that's what I have to tell you. Frankly, I don't make the rules. I can only tell you how they assess things. Okay, next one. If I'm an overstayer in the UK and apply for spouse visa outside the country, let me read this question. If I'm overstay in the UK and apply for spouse visa outside the country, is overstay affected my entry clearance? Overstay does not affect, but if you have overstayed, definitely do it through a legal representative. We have done many similar cases of overstays where people have overstayed 7 years, 5 years, and even more. But the relationship aspect will be tested very well. You can do it through any lawyer, any legal representative, doesn't matter, either through us or someone else, but always file it. I would advise it because your overstay and all other reasons should be addressed properly in your application. So that is something I would suggest. But yes, overstay does not affect the spouse visa application from outside UK. Okay, I don't have any live questions. Let me take the questions from the channel. This one. From a channel member, I need your advice in this case where I applied for a spouse visa for my partner. We were not married. Now the visa success. We were not married now, but we have separated. Now that she's still in my visa, what to do when I want to apply for new partner? Applied for. Okay, so relationship breakdown situation. If you have a situation where you've already sponsored someone on a spouse visa or partner visa and the person is no longer with you, you need to report it to home office. I think you want to apply for your another partner, the new partner you have. So the one who you have sponsored has moved on, left you. So you need to do the reporting from home office. If you Google search for report relationship breakdown to home office, you should get the form, fill up the form, submit it, and then home office will cancel the visa of that person, the previous partner. And then once you've done the reporting, then you can apply for, I think after your reporting you don't need to wait for other steps. Once you report it, that's done, then your new partner can apply if they meet all the eligibility requirements. Okay, I have to cross the road. Okay, I have another live question. Let us see. My student status expired on 20th Jan. I apply without cost and I'm waiting for cost. Okay, student status expired on 20th Jan. I did not take biometric appointment. It's 13 days now. How much days can I wait till cost? So student visa permission is expired on 20th of Jan. You applied without cost. So you applied for a skilled worker visa without cost. Always do that through immigration representatives. It is not advisable. Anyways, you have done it. But yeah, I'm not sure how long they're going to hold it. But when we file it, we always do a legal representation letter, send it to the case working team and ask them to keep it on hold and give them any evidence that the sponsor has applied for sponsor license or they have applied for costs, whatever is the status, it doesn't matter. Some evidence is required, or maybe at least a letter from your employer saying that we have applied for costs, we are awaiting a decision on that cost. It takes up to 18 weeks for the cost allocation. So a letter from them and confirming that they are willing to hire you and all the details of your job, salary, hours, job title, etc., etc. So some supporting letter from your employer, that's what we do. I'm not sure how you would send all these things to the home office. Usually it should go as a legal representation, so that you are requesting them to keep the application on hold. So that's how it is usually done by legal reps. But preferably such application should always be done through legal reps. You can go to any legal representative, but that's how we request home office. And so one of the risks that is always there is, even when we do it, we never guarantee success, because in this case not giving a cause is a fail on the validity requirements. So if you look at the appendix skilled worker immigration rules, it clearly states for the application to be valid, you need to have a valid cause issued within 3 months before the date of this application. In your case, that is not the case. So home office always has the option of rejecting your application as invalid. So you are always taking that risk, remember that. Hence, that's the reason I am advising that always go through legal representatives. We have different channels. We send it to seniors, case working team and all of that. And we've done many of such applications in the past, and every time we have got successful approvals. They have never refused it on validity. So it's just from experience, but yeah, that's how we do it. That's what I would suggest. Yes, yeah. Ask your solicitor how long they have told you to provide the costs. Yeah, I have done myself at least 3 to 4 months. I have stretched them. I know that in the past, where sometimes even the sponsor didn't have a sponsor license also, and so we just applied for the sponsor license, gave them the SPL reference number, told them we've applied for a license, and once we get the license and the cost, then we will assign it. So up to 4 months I have stretched it, and I know they do keep on writing asking for it, and we repeatedly buy more time. That's what we have done in the past. But yeah, so that's what we have done in the past. That's from experience, I can say. So up to 4 months or so, I remember we've done several applications where even they didn't have a sponsor license sometimes. Sometimes it was just for undefined costs. Depends how much experience your solicitor has doing all these things, but this is just from experience. If we were there, I would have stretched at least up to 4 months or so. Very easily we've done that, or even more rather. It's not that, because it's not a matter of how long it is. because it's the home office problem and the other department is loaded with work, and yeah, that thing cannot be, you cannot be penalized for the other department's inefficiencies of 18 weeks processing time. Okay, so yeah, so okay, thank you, Aves, thank you. I'll take some questions on the channel. Anyone coming live can ask their questions. So this one is done. Let me take another one from a member. My visa will expire on 15th of February. My CAS letter already over successfully on October. I got a receipt from dissertation which is submit in July. Can I switch to skilled worker visa? So I think the individual is talking. I think the member of Avijit is talking. My visa will expire on 15th February. So he's talking of a student visa. The CAS letter is over, which means successfully completed the course of study. But he has failed it, I think. So he's got a resit, and which is submitting in May and July. 15th February plus, I'm just doing the total how long you can delay it. 60 March, April. Yeah. And his result will be out in July. Yes, you can switch to skilled worker visa. The question is whether you can switch to skilled worker visa. So I'll answer specifically for that. So yes, you can. Once you completed the course of study on a student visa, whether successfully or not. So for a graduate route visa, you need to complete the course successfully. But for a skilled worker, you are switching to a skilled worker, your course should be completed, whether unsuccessfully or successfully. It doesn't matter. Even if you failed, you got a diploma or whatever that is. So yeah, if you are a bona fide student, your university has not reported you as not studying with them, not following their policies or whatever, you have continued to be a student, proper student, and then completed the course as normal, but you failed. So in that case, you can switch to a skilled worker visa. So have I reached? Let us see. I think I have reached maybe that one. Sorry, I'm trying to find the house. Okay, where is it? Anyone coming live can ask your questions. Yes, by the time, let me locate the house. I think this is the one. I have a feeling. Yes, I think this is the one. Let me see. So, Nipa House and 94 Bespero. Yeah, this is the one. I will cover. So what is happening over here is, so she is one of my family friends. So she is setting a Guinness World Record of playing a piano for at least 11 hours or more. And I think she started, there may be other viewers also. There are several cameras. She is also live on YouTube. So I'm going to show you a glimpse of that. And also I will be answering your questions anyways. Anyone coming live can keep on asking the questions. So I will change the direction of my camera. I'm still on. I'm seeing, and I will show you that, and you can keep on asking your questions anyways. Let us see. Okay, so I am here. I did lock it. What happened? Ooh, I've locked the doors. Let us see. Let me try what I can do. Okay, I have locked the door. Maybe let me try calling from another line or this line only. I'll be live again. Okay, I am back on the live. I hope I am back. Let me check. Yes. Okay, stay connected. I'm trying to get through the door. Just 1 minute. Okay, how do I do it? Okay, I'm back on the live. I will continue to take any questions. I'm waiting for someone to let me in. Okay, and then I will do the coverage of that thing happening. Let us see. I'm pretty sure this is the place, Signature House. Okay, I have a question live. If someone overstayed in the UK, after go back to home country, they can apply student visa after 1 year. Yes, you can, but remember, they are going to assess your student visa application quite carefully. They need to see that you are a genuine student and your intention is to study in the UK and not just to come to the UK for other reasons, whatever you want to live in the UK or something. So when you apply for if you have overstayed for more than 90 days, then you will have a 1 year ban anyways. Under that, there is no ban period, but then if you overstayed for more than 90 days and you left at your own expense, then you will have a 1 year overstay ban from the point you left the UK, and after that only you can make the student visa application. So yes, you can, but they will be assessing the genuineness of your student visa aspect very, very carefully. Remember that. Okay, so for example, in the previous question, somebody asked an overseer, can they apply for a spouse visa from outside the UK? In that case, I said that they will check the genuineness of your relationship very well. In your case, they will check that you are a genuine student, and that is something they will check very, very carefully. They may interview you, etc., and they will assess that aspect quite well. So, okay. I will take some more questions maybe. Let us do. Is this the correct place? I don't know. Okay. Yeah, anyone coming live can ask their questions. I'll take another question from a member. This one is done. Sir, I have applied. Okay, thank you, Navin. Sir, I have applied for skilled worker visa with my dependent, and they asked my wife for many this like payslip, pay 60, on rate of employment, 2 years of living together recommended by friend and family. Does it mean? Yeah, so if the question from Himala, I think that's the name on the channel. Yeah, so you are a member, you applied for a skilled worker and you have been asked a lot of questions. That is common. You applied for a main applicant and a dependent partner, and they've asked for P66 contract of employment, 2 years of living together. So the 2 years of living together evidence is for your partner who is a dependent. They want to see, yeah, they need to make the relationship requirement as per the appendix relationship. So the 2 years of cohabitation is required for the dependent partner. If they've already got previous leave, yeah, from that point till the date of your application, that they have lived together, various documents, council tax bills, etc., other bills addressed to both of you or jointly or severally at the same address. So that is one thing. And contract of employment and all, yes, they may be in checking your case whether it is genuine employment, if there is a genuine vacancy. So they may be asking your current situation. I'm not sure about P60. Which P60 are they asking? Because if you have never worked for your future employer, there is no P60 in question. They may be asking for your previous employer, maybe if you are switching from one skilled worker to another, maybe changing employers or job codes. Yes. So you will have to provide all of that. If they are questioning that, what does it mean? It means that you need to provide that. That's what it means if they've asked for it. Okay. I have next question from another. Okay. I have two more questions from channel members. I'll cover them. Can a person on PSW register a company, do a self-sponsorship, level skilled worker visa? How long should this company be run to qualify for sponsorship? How much should an investment in UK mentality? Okay, so this question is about self-sponsorship for a graduate holder. Home Office, so just latest update. In the last 6 months or so, 3 to 6 months, Home Office has been refusing all self-sponsorship applications. I know other consultants are making money, making advertisements everywhere on TikTok and other social channels where they are selling this self-sponsorship game. Home Office is not happy with this. We have already confirmed with Home Office they are going to come up with some latest guidance that they are working on. And now they've started refusing these self-sponsorship applications. For genuineness, they say it's not a genuine vacancy. It's just created for the migrant to get this some type of visa. So self-sponsorship is almost the way they are killing other areas. FLR, others for buying time is killed. People being put on immigration bails immediately as soon as the application is filed, sometimes within a month. Fee waiver application, after rejection or refusal, file an application. They are refusing that because the fee waiver guidance has changed. You can only make the same application. So when you file the fee waiver, you say I will make a human rights application, but subsequently you make something else. You file a graduate route, skilled worker, or anything like that. They are refusing that one. So fee waiver is dead. FLR, buying time, is dead. This third area is also they have got to it. Home Office, this is what happens. Home Office observes all these things over a period of 1 or 2 years, and then they start killing all these areas. So all these buying time applications are dead, number one. And the self sponsorship, they have been looking at it for the last 2 years. A lot of abuse happening, and now they have started killing it. They are refusing left, right, center, all of this self sponsorship. So all other questions almost become irrelevant. I know you're asking, you're on PSW, you want to do all of this. If you don't have, there are very less prospects of success. In the past, yes, we've also advised and helped individuals where there was a genuine business and everything was genuine, but from there, basically, yeah, it has not been possible to it has not been possible now for any self sponsorship situations. Okay, I think I have got the access. Thank you. I'll just. Okay, I have got the access. Okay, maybe I can. Okay, so yes, I am inside now. So again, to recap, I hope she will be paying. So yeah, we have, as I said, she is going to play all these instruments for several hours, maybe 11 hours. So you can see she's setting up a new Guinness World Record. I don't want to distract her, hence I will be very quiet. I'll just give you a glimpse of it. And so this is what is happening, and I'm just covering on this channel. I'll put a link. I don't want to distract her, so I will go out. So that is what she's doing. So she's going to continuously play for about 11-12 hours. I will keep on taking any questions. Maybe for some time I will cover her, and if any questions come, I will answer them. Okay, in between I will take some questions. Let me see if I have anything on my channel. So the next question I have from one of the channel member is about, would you please answer the following? Can a person on PSW register a company? Okay, that's what I've answered. So the PSW area, self-sponsorship is almost dead. I'll take some other questions on the channel. So I will take some questions and also go live. Okay, I'll give you a glimpse again if this interests you. So I have to also sign the document that I have seen it. I will wait for some time. Maybe I will cover it, wait, sign the documents, and if any questions come, I will answer them. So if you all are live, ask to be quiet. I need to sign that declaration. So I'm covering her. I am signing the declare so that I have seen this. Okay, so this is a Guinness World Record. Yes, everyone can see this. So I'm signing this declaration. I have witnessed this event. So I will be continuing to fill up the form without disturbing her. 2406 1209 0228L. Okay. So this is the Guinness World Records form. Witness statement template. So I have signed it. I'll fulfill the other particulars subsequently. You all can keep asking me any questions that you have during the live. I will cover them. So I will give an update on this, what is happening subsequently on the channel. For now, I will continue this. Anyone interested, keep watching, and it will be recorded on the channel anyways. So yes, anything, write in the comments. I will tag her Instagram profile as well. So if you are interested in such topics, do follow her. Anyone coming live can ask your questions if you wish. I am still live. I am seeing your questions. I will address them if I see any live questions on the channel. At the same time, so this is my friend who is going to set a Guinness World Record for by continuously playing this musical instrument for about at least 11 hours, and her target is much more than that. So that is what is the goal. It's a Guinness World Record. Even I am witnessing this for the first time. I'm observing this, and I have never done in my life. Anyone interested, you can watch. So this is ask any questions you wish to, get your immigration questions answered at the same time. Yes, you can enjoy this live session. It's also being recorded live on YouTube. You'll see different setups over here, which are over here. So there's several cameras, several live setups, and several witnesses who will be. Good morning. Anyone joining live can ask their questions. Thank you very much for all the hearts. Yes, thank you for all the love. Good morning, Babakar. Parent visa waiting times, they still remain the same as I've answered in previous lives. Parent visa waiting times have remained the same. Babakar, thank you for being a member. Thank you for joining. Anyone coming live can continue to ask their questions. I will be addressing them. I am live, just that you cannot see my face. This is one of my friends who is setting up a Guinness World Record by continuously playing the instruments for at least 11 hours or more. So I'm just covering that on my channel. Feel free to ask any questions. I am live. I am, I am still live. Anyone joining live can still ask any questions that you have. I will be addressing them. This is one of my friends who is setting up a Guinness World Record of playing this instrument for at least for about 11 hours. That is the goal, and I have come here to witness this. I have also signed the witness statement. Hence, I have to sit and observe for a certain amount of time and confirm the timing as well. Okay, I have a question. If you can hear me, if not, just let me know. I will try and cover the question in a case where started that application was which couldn't get all your attached documents. So you filed a application to switch, but you don't have all the documents that are required as per the immigration rules. If your current visa expired, I don't know what documents you are missing. If you are missing the main documents, for example, a cost for a skilled worker visa, etc., it may be a problem. So it is something you need to speak to an immigration lawyer and take proper advice on it. There may be some options to buy time, but other than that, it's difficult for me to tell you exactly what you can do. I don't know what the reason for the delay is, etc. But if you give more details, maybe I'll be able to address what is the problem, why you cannot give the documents, when will you give the documents, etc. etc. Anyone coming live can continue to ask the questions. So this is, I have come to witness a grand event. This is one of my friends, Siddhi Kapsekar. Siddhi Kapsekar is her name. I will put more details about her, her Instagram handle on my channel in the description of this video. So that was, I have come here to witness that as well. I have signed a document which is the witness document for the amount of time that I have observed it. I have given my contact information. So if Guinness World Records, when they want to affirm, they can contact me. This video will anyways be live, so that itself is an evidence, and 7,000 subscribers are on the channel who will be evidencing this video as well. That particular event is also being broadcast live on her own YouTube channel. I am assuming that, I think that's what I have been told. And yeah, so she's going to continuously play. I am here to support her, observe her, give her witness statement, and at the same time, I'm also answering your questions, all the channel members' time. I don't want to waste your time. I am taking whatever questions are coming through. I am watching all the questions. Now, since I have the 5-minute break, so yes, anyone joining live, ask your questions, or I will give an update which I had on my on my list. So one of the important updates about skilled worker visas that you will see is that no employer can recover any cost with respect to skilled worker applications from the applicant. The cost of the sponsor license cannot be recovered. The cost of the certificate of sponsorship, which is 239 currently, it may rise up to 525, I think. So that cost cannot be recovered from the employee. The cost of the immigration skills charge, which is 364 per year of visa for small employers and 1,000 per year of visa for large employers, that cannot be recovered by employers. What else? Any administrative costs, kind of legal costs, those are arguable, but the first position of Home Office is that we have asked Home Office on this. This is a recent development on, and I think this, so that's the latest, I think 31st December or January, the guidance that did change, and it is a recent development from January onwards. So any costs assigned after 31st December 2024, all these things are not allowed. No cost recouping is allowed in either way, in however, from salaries, in advance, later on, the costs have to be borne by the employers only. It's a very, very big update because employers have been playing around with this for a while. A lot of abuse has happened. Hence, in this area, Home Office has started stopping employers from doing all these things, selling of visas, buying of visas, where employer is just acting as a conduit to give a visa to someone, taking all the monies from them for the expenses, everything, all of these things, plus whatever benefits they are getting out of it. So that business is completely being challenged. It will be almost being shut down because now employers cannot recover cost. If Home Office comes to know any part of the cost has been recovered, they will cancel the license. They will also curtail the visa periods, the permissions that have been granted. So this is a very, very important update. No costs can be recovered by an employer, by a skilled worker employer when they give a cost, and it's only for skilled workers because the abuse was happening on skilled worker. They are not stopping the cost recovery on other visas which are sponsored visas, tier 5, GAE, government authorized exchange, or others. There are several others, religious worker and all. But the only restriction about cost recovery is on skilled worker visas. Cost recovery is not allowed in case when a skilled worker application is made, either the cost fees, ISC, any fees rather. Even the administrative costs we questioned, we have asked Home Office in the first instance as to what is the position with lawyers' fees, like my fees or any other lawyer's fees, if that is also a part of the whole equation, then can the employee bear it? Home Office first position is that the employee cannot bear, the employer has to pay all administrative costs. For example, priority service fees for sponsor license application, that definitely employer has to pay. Even the cost of our, even yeah, the cost of any administrative things that we are doing, for example a lawyer's fees, priority service fees, everything. The first position of Home Office is that all costs need to be borne by the employer. Yes, there will be some discussion around, I understand that the legal charges may be relaxed. I think it's an arguable point. The lawyer's charges, sometimes the employee may say that I want a lawyer, the employer may not be in favor. That's fine. I think lawyer's charges, can either of them can pay. That's our first position, all our lawyers. But all the government fees, that has to be borne by the employer only, employer. Any recovery from the employee will lead to sponsor license revocation, and very strictly they are going to do that. So that is what is coming. So that is the change. And another update is 1500 sponsor licenses have been cancelled in the last 1 year. That has been record cancellation. So that is another update that I wanted to give on the channel. 1500 sponsor licenses cancelled. It's quite a record. Majority of them, I think, in the care working sector, and other sectors also they have been cancelling. So a lot of challenges on the skilled worker costs, licensing, etc., etc. Even when licenses are applied by startups and all, a lot of questions are asked where pre-revenue companies, where you just have registered the business, no revenue generated, no trading done, etc., etc., no profits, nothing. Yes, Home Office is coming back with a lot of questions, interviewing the authorizing officer just before giving the sponsor license, pre-license audit, either interviewing the authorizing officer, sometimes even interviewing the authorizing officer, physical visits, virtual audits, asking many documents, etc. So that is another update. So licenses cancel, Home Office is making this area very strict. It is interesting to see in the next 1 year what is going to happen to the number of licenses applied, number of skilled workers sponsored, etc. We need to see the data and judge from that. I think in the last 2 to 3 years, a lot of abuse has happened, and that is what this has all led to. They are killing it on all aspects. They're checking on sponsor license. They are checking when you ask for a DCOS, asking for documents, interviewing candidates. They are checking when you apply for UCOS. They are interviewing inside UK. So this is a new development, very new development. I think last 3 months or so. Inside UK, even if you apply for a skilled worker visa, if you are switching for the first time from any other visa category, they are interviewing the candidate also to check that the job is genuine, everything is genuine, there is no buying and selling of things going on over there. So yes, that's it. And so that is the main update. I will continue to give some more updates for 5 to 10 more minutes. I will cover. So anyone joining now, I have to witness for some time now as well. I have come here to witness one of my friends. She is playing a musical instrument, and the goal is she is going to continuously play for about 11 hours or so. And yeah, I have come here to witness. I have signed the witness statement. I have to spend some time watching it. I'll give you a snap of that. You will watch it. You will hear it. At the same time, I will be live, so you can ask me any questions, and you can continue to ask any questions. I see the questions. I will try and answer from this mic very quietly. And yeah, So feel free to ask any questions. Let's continue. I will change the direction of the camera and then I will go in. Okay. So feel free to ask any questions. I am live. I am watching the questions. And Babakar, for the parent visa, the waiting times have remained the same. I think it is 12 months or so. So thank you very much for joining, Babakar. Thank you for being a member. Yeah. And if you are unable to hear me, let me know. So the mic is here. I will be talking very softly, but you will see that. You will also get your questions to your immigration law issues answered. So here we go again. So here I am. I'm back. You can keep asking me any of your questions. Feel free to ask any questions and I will be. So feel free to enjoy the music. This is a Guinness World Record being set over here. Thank you. So you will see that there are various recording devices. There is time being recorded. If you see on the right side, there is a timer. There is a YouTube live. There are several cameras covering her. There are people witnessing her as well over here. Yes. Feel free to ask any questions. I am still live and taking questions. Okay, I did answer your questions. Please provide some more details about your case. What is the thing that is missing that you cannot upload? Why you cannot upload and when will you upload it? So if you tell me the reasons, then I can tell you how to address that. Thank you very much, Vishal Sharma, for joining. Yes, so this is one of my friends, Siddhi Kapshikar. She is setting up a Guinness World Record of continuously playing this instrument for at about 11 hours or so. I am here to witness this, to sign a statement Hence, I have to observe her doing this particular in the act. And the time that I have observed her, I have to sign, and that's what I've already signed. Hence, I am sitting here, I am live, I am taking questions, and at the same time, I am doing a coverage of her on this channel. So, anyone interested can watch this. Her name is Siddhi Kapsikar. I will put her social handles on in the description of this video. And yes, you can follow her and enjoy the music. I will address this question in about next 2 to 3 minutes. Yeah. Okay, so I am outside now. I'll ask a question. I see that question. Give me 1 minute. I will get out over here. And yeah. Okay, so to answer that one, you have been waiting for a while. Let's see. What is the question? Okay, so in case where you started your application for switch or break, but you couldn't get all your attached documents before your current visa expired, midway, what is your options available? So you submitted the application without the cost, that's what I understand. Okay. So, and my employer is yet to release the sponsorship letter. So he hasn't given you a cost without, so you have applied pending costs. Ideally, yeah, as I advised to a previous viewer who asked this similar question on this live only, you should always prefer to do it through immigration lawyers so that we have different channels where we tell home office case working team and even raise it to senior case management if that required to ask them to keep it on hold. But then if you done it through your lawyer, maybe your lawyer should already write to home office asking for more time, that the cause is in progress or whatever that is. But there is not much that you can do. If you already submitted, one of the risks that you have taken is it can be declared as invalid and refused. That risk is always there. It's one of the validity requirements that you need to give a cause. But your employees may have applied for it. Maybe, yeah, just get a letter or something, and your legal rep should write to home office asking for some time and keep the application on pending till they provide the cause. So whatever other reasons should be explained properly, addressed to the case working team. That's what I would say. If you've not done through an immigration lawyer, maybe speak to an immigration lawyer. You can take advice from us or anyone else, any other immigration lawyers. But yeah, handle it properly. There is a chance that they may declare it invalid. So it's always good practice to tell home office in advance that there is some hold up, there is a problem, and you will be providing it subsequently. Give any proof of genuine employment that you can. So that is my advice on that. pending cause application should preferably always be done with immigration lawyers. Anyone else coming live can ask their questions by the time you have to walk back. Okay, so how do I? Okay. I will be walking back now. Let's see how to open it. Anyone joining live can continue to ask the questions. Let's push. Okay. So that was one of my friends. She's setting up a Guinness World Record, and I came to witness her and sign the witness document stating that I have observed her doing that for a certain period of time. So I've confirmed the timing, etc. And I've shown you the Guinness World Record from just previously on this live only. To have a one-on-one consultation, in the description of this video only or any other video, you should have a link over there where you can book the consultation yourself. So in the channel description, in the description of this video or any other video also, you should have that. So let us see, what do I have? Do I have my water? Yes. So now okay, I'm outside again and I'm ready to take any questions that anyone may have. Some of the important updates, as I said, I will give some other updates. I have it on my list. Let me open it. Where is it? Okay, so yeah, if you are thinking of updating your passport on your e-visa and you have an application that you're going to file in the next 3 months and you don't have any plans of traveling outside the UK, I would say stay away from updating your passport. Just keep the access through your expired BRP also, that's fine, or any BRP that you had, because there is some system issue that is still not being resolved when you are trying to file an application where you are accessing your e-visa through your passport details. And if you're trying to use the immigration ID check app to make any application, the system is not helping out. There is some system issue. Home Office is still trying to resolve it. So that is my suggestion. Then the app is not helping. The UK immigration ID check app, it's playing funny, or it's not allowing you to. It's not basically recognizing and taking the biometrics from that. So this is what is happening. So avoid updating if you have an immediate application. So if you are going to file an application very soon in the next 3 months or so, yeah, don't update your passport at this point. Just keep it to your expired BRP till this is sorted. Okay, next question. There is a live question. Let me see. Okay, over here. Is there any price changes for costs? It's not yet passed. The price is going to increase to 525 highest. I think it will not go up to that end. That is the highest level that it can raise up to. So yeah, be prepared. It can go up from 239. It hasn't been increased. It's not yet passed, I know. The bill has been presented, but very soon, in a week, 2 weeks, anytime it can be passed. So it will go up to 525 or 535, I think so. Do we need to have passport with us? Apply pass के लिए visa. Yeah, you need to have a valid passport when you make an application, because if Home Office requires, they may ask for a passport. So you should have a valid passport when you apply throughout the time till you get a decision for a skilled worker visa. Okay, anyone coming live can ask their questions. I am live. I'll be live for about 15 minutes more, I think. Yeah, 15 minutes is enough time. Some more updates. I have my sheet over here. Let us open it. Where is it found? Okay, so this one is gone. Yeah, nowadays, since there's another new scam going on, so I haven't made a video yet. I have made on that FLR issues. Home Office has been putting people on immigration bail. Fee waiver issues where they are refusing applications after fee waiver. Now one more new thing that has come up, agents or whoever these consultants are, they are trying to file EU settlement scheme applications because you get a certificate of application immediately and you can work. That would just ruin your whole immigration career future in the UK, so don't do that if you don't have a valid basis. And there are 99% people don't have a valid basis. I know that because the timelines have already passed for the EU settlement scheme. So that's another one. Don't fall prey. I know whatever your reasons may be, but don't fall prey to just filing these EU settlement scheme applications, frivolous ones, where you don't have any basis. So next question. Don't have any questions. Let us address something that I have on the channel. Turn left. Is that the left? Okay, this is the footpath. Yeah. Anyone coming live can ask their questions. Let me take some questions from the channel. Hi there. Okay, let us see. Please, do I need a new course to extend my healthcare visa when it expires? Yes, you always need a new course when you extend your visa, whether it is healthcare or any other skilled worker visa. You need a new course. This has really solved my puzzle. Okay, so sorry, this application. So this question is about EU settlement scheme application. So you have had an admin review pending for 3 years. Okay, yeah, that's normal for admin reviews. And so slow. So it says, I'm waiting for an admin review. I have been thinking of traveling outside many times because I have business. So this question is on the issues with any EU settlement scheme applications that are pending or admin reviews or appeals pending, and you have a certificate of application. As per the EU settlement scheme rules, withdrawal agreement, etc., you do have a right to travel in and out of the UK on the basis of that certificate of application, even if you have a pending application, pending appeal, pending administrative review. So Horse of Wisdom has asked, his admin review is pending for 3 years. He wants to travel outside the UK, but I know that at the border, Home Office has been creating some issues. That's what I've seen. Even the Home Office guidance has been changed. The Border Force guidance, where people are, anyone who is trying to enter on a certificate of application, the Border Force officers, immigration officers are trying to act as immigration decision makers or an appeal judge, and they are trying to go through all the documents and assess whether there is a genuine possibility of success in your application, whether you genuinely qualify under EU settlement scheme or not. And if they are not happy, they have refused many people the entry into the UK. They have refused, asked them to go back. So that is the one. I would still say, if you have something pending, if you don't have strong documents to prove, whatever is your basis of stay on that EU settlement, avoid traveling. If you are stuck with an issue when you try to come back in, yeah, that may be a concern. So be mindful if you are thinking of that. So Adreg, thank you for becoming a visa navigator. Thank you very much. Yeah, but Odrek, that is just becoming a member. That's not a consultation. There should be another link to book a consultation if you want a one-on-one advice with the immigration lawyer. If you want to speak to me, there is a 30-minute video call. This is just supporting the channel that you have, if you have done it by mistake, just to clarify. Okay, if you want to support the channel, that's very good. Thank you very much. Okay. So next question I have, can I come back to UK if I have travel history of UK dependent visa? Can I come back to UK? So I'm trying to interpret this. So you have already traveled to the UK as a dependent visa on someone else, and now you want to come back to the UK on some other visa. Yes, you can. If you do qualify, you can apply. If you no longer qualify for the dependent and you have some other visa, you can apply for it and enter. Yeah, if you want clarity, please give me more details, then I can understand your question if I'm not understood it correctly. So tourist visa, yeah, tourist visa you can apply. It's nothing wrong unless you have broken the immigration rules, you have overstayed, or any other issues that you have that are on your record. So other than that, if you came to the UK as a dependent, went back within time, everything was good, yes, there is nothing stopping you from applying for a visitor visa if you do meet all the eligibility requirements of that visa. Anyone coming live can ask their questions. I think I will be live for 5-7 minutes or so, maybe 10 minutes. Yeah, I'm still walking. I will be crossing the road, so feel free to ask any questions you may have. Yeah, if you came with a valid visa, you left within your time, etc., then you should be fine. You can apply for a visitor visa, but they will check the visitor visa on its own merits, whether you really want to visit, what is your plan, etc., your ties back home and all. So yes, you can apply. And I have a long-winded question. Let me read that from Flunk's Nectar. So you came with the care home and the sponsor license got revoked, etc., and something happened. And the question is, I came with the switched visa even this year. Yeah, I would advise against buying any sponsors. But yeah, please do clarify your question. I know you have expressed your issues, but yeah, I can only advise on immigration rules. I don't make the rules. I can only advise on how they would be interpreted, etc. But yeah, so I think, what is your question? I'm trying to get in that long paragraph. Possible. Yeah, I know that with the care homes and all not giving work, it's difficult to find jobs. I agree with that. So 5 successful jobs. Yes, you can switch to another employer. So I think summarily I got it. You have not worked with your previous employer sponsor, and you are asking, do I need proof that I have worked for previous sponsor before switching to another employer? No, you don't need proof. I've never seen that. As a part of the application, also in the immigration rules, there is no requirement for you to prove that you have worked for your previous sponsor. So I know this is a problem with this care home sector. So you don't need to worry. If you have a new sponsor, you can apply to switch to the new sponsor. So that is my answer summarily to your main question. Okay. Yeah, Odrek, that YouTube membership doesn't give you any consultations with lawyers. You can cancel that immediately if you want to. YouTube will give it back to you, whatever you have paid. It is not the membership that I'm referring to. If you want a consultation, there should be a consultation booking link. That's a 30-minute advice, and it goes on the website. And on the website, you pay and you book the consultation. So that is what I'm referring to. If you have inadvertently booked this navigator, this just to support the channel, etc., and all. So with that one, and you get some early access to videos and all of that stuff. So that one, if you've done it by mistake, you can cancel it out right now. YouTube will just refund it to you. Okay, next. So Frank's question is, next live question, when an appellant withdrawn the appeal, can you re-appeal again or do new application, please? Re-appeal again. Yeah, if you withdraw. No, if you withdraw an appeal, you cannot re-appeal. If you withdraw an appeal, let's say today, you are out of time from today, you are an overstayer from tomorrow. Remember that. You may be able to make a new application within 14 days, but that is still an out of time application. If you are meeting the requirements of the new application, then yes, you can make the new application. It will be considered as per section 39E of the immigration rules, where you file a new application within 14 days of withdrawal of the appeal. So you cannot file a new appeal, but yes, you can make a new application. But remember, you are an overstayer. So let's say you withdraw the application today. You withdraw the application on 1st of February, okay, for example, and then you file before 15th of February, which is within 14 days. Another application, that application will be considered, and let's say you get a new approved visa on the new application if you meet the requirements from say 1st of March or say 1st of April, for example. So from 1st of February when you withdrew the appeal till 1st of April when you got the new visa, you are an overstayer in the UK, and yeah, that affects all your 10-year route and all of that. It doesn't break your continuity of residence, but yes, that is something you need to consider. Speak to an immigration lawyer before you decide to go ahead with all these things. Okay, welcome. Visa loan before 11th March. So your wife, okay, loan. She invite me on a dependent. Yes, she can invite you on a dependent visa if she has the main applicant skilled worker before the changes happen. So yes, she can do that. She can sponsor you, because care workers who are in the route before 11th March, before 4th of April 2024, so 11th March is in the old rules, then yes, she can invite you to join. She can sponsor you as a dependent. Okay, so let me see if any update I can give, and let us see, where am I? Yeah, I'm not understanding your question, Aman. She applied alone for her skilled worker visa. Now you want to join as a dependent. You can join. If you want to apply as a visitor to visit her, that will be checked on its own merits. So that's my answer. Okay, on the channel, let me check which is the link I'm trying to see. Yeah, if you open any of the videos, there is a link to book the consultation. That's what I can say. I don't have access to it, but yes, if you open any of the videos, it clearly says to discuss your case in detail, please book a paid video audio consultation. So that's the link you need to click and book the consultation. Okay, and after this call is saved, you will see the link in the description of this live also. It is automatically saved, so you will see it, or open any other videos in the last 4 weeks or so, you will see the link which says to discuss your case in detail, please book a paid video audio consultation, and the link is there under that. So that's it, and thank you very much. Okay, so Frank, let me just cover this. And can this withdrawal or cancellation of you family sponsor affect appellant you sponsor? I don't understand how, who is the appellant can only withdraw the appeal. So who is withdrawing what? I didn't understand. The appeal can only be withdrawn by an appellant, not anyone else. So yeah, if you don't have a U sponsor who is willing to help you with the appeal, maybe they were a sponsor before, now they are no longer your sponsor, yeah, you should withdraw your appeal, and then you may have to leave the UK if you don't have any basis of living in the UK. So that's what my advice is. And everyone, thank you very much for joining live. I have to end this live now. Thank you.